Now, with this union budget, amongst other changes under customs, few of the important amendments have been proposed under the existing set of rule, that is customs import of goods at concessional rate of duty rules 2017. Now, the amendment essentially seems to be in line with the motto of ease of doing business. Presently, a large number of importers are taking advantage of concessional rate of customs duty under these rules against those goods which are essentially imported for use in domestic production of specified finished goods. However, the present procedural requirements to avail such benefit are cumbersome on several counts. Firstly, as it involves multiple reporting requirements. Secondly, various intimations and permissions are required from the customs authority. And lastly, the entire process is administered manually. Thus, what we have seen is that practically at ground level, importers have been facing challenges to comply with the existing set of rules and resultantly have been subjected to litigations. More so on account of discretionary powers which are exercised differently by different customs port authorities. In fact, just to highlight, in one of a recent decision of the Honorable Madras High Court, in the case of Medrich Sterilab Limited, it has been held that the procedures prescribed under the rules are to be strictly adhered to, which then naturally has added to the difficulties of the importers. Thus, the proposed amendments under these rules, which lay down simplified procedure, is a welcome move. Some of the key notable amendments, which will be effective from 1st of March 2022, are as follows. First, the entire system of filing, be it the one-time intimations, returns, etc., have been automized through the customs common portal instead of the present manual filing requirement. Secondly, clearances with duty benefit will now be automatically processed by citing a unique number which is issued at the time of initial application. So one need not to wait for the authorities to give permission to avail the exemption benefit on every such import. Thirdly, the requirement to provide details of estimated quantity and value of goods which are proposed to be imported on an annual basis has been done away with. This is a very critical amendment, given that every time an importer need not to prepare and provide such details to the customs authorities. So it will be now a streamlined process. And lastly, and most important, the requirement of taking permissions and intimations to the customs authorities, such as intimation on every receipt of goods imported that such goods have reached the premises of manufacturing, that obtaining permission of the customs authorities every time when goods are sent to a job worker, or obtaining permission of the customs authorities on re-export of such goods, or to clear unutilized or defective imported goods. All these requirements which sort of gave a discretionary power to the authorities to either to grant permission or to refuse that permission has been done away with. So overall, the proposed amendments have been done in order to ensure that these procedural ambiguities which are there in the existing rules are removed and a simplified set of procedure is introduced henceforth. Thank you.